Before we begin, a quick and important disclaimer. This video is for educational and entertainment purposes only and does not constitute professional financial, legal, or tax advice. The laws surrounding divorce, asset division, and retirement accounts like 401ks are incredibly complex and vary significantly from state to state, particularly within the diverse legal landscapes of the U.S. Midwest. The information provided here is based on historical trends and general legal principles, but it should not be used as a substitute for the counsel of a licensed attorney or a certified financial professional in your specific jurisdiction. Every individual situation is unique, and the potential outcomes of a divorce settlement depend on a multitude of factors specific to your case. Always conduct your own due diligence and consult with qualified experts before making any decisions regarding your financial future or legal standing. Imagine you have spent 25 years working at a manufacturing plant in Michigan or a corporate office in downtown Chicago. You have diligently funneled a portion of every single paycheck into your 401k, watching the compound interest turn a modest start into a mid-six-figure nest egg. You have foregone vacations, driven older cars, and prioritized your future security. Then the unthinkable happens. Your marriage of 2 decades reaches its breaking point. As you sit across from a mediator in a quiet office in Des Moines or Indianapolis, you realize that the $1 million you thought was your ticket to a comfortable retirement is suddenly on the chopping block. In the eyes of many Midwestern courts, that money doesn't just belong to the person whose name is on the account. In fact, there are historical trends where individuals have lost nearly half of their life's work in a matter of weeks because they didn't understand the specific mechanics of Midwest property division. This is the reality of the 401k divorce in the United States Midwest, a region where the laws of equitable distribution can lead to surprising and sometimes devastating financial shifts. We are opening a loop today that most people don't realize exists until it is far too late. The secret language of the QDRO, the hidden tax traps of the 10% penalty, and why 50-50 is a term that rarely means what you think it means in a Midwestern courtroom. For the millions of Americans living in states like Ohio, Illinois, Wisconsin, Minnesota, and Missouri, the rules governing your retirement are not as straightforward as a simple math problem. This video is designed to be a deep dive masterclass that solves the primary problem facing anyone going through a transition in the Midwest: the fear of the unknown. We are going to dismantle the complexities of how retirement assets are valued, divided, and transferred. We will look at case studies of how a valuation date can swing a settlement by tens of thousands of dollars, and why the specific language in your divorce decree might be completely ignored by your 401k plan administrator if it isn't drafted with surgical precision. By the end of this series, you will understand the framework that judges use to determine what is fair, how to protect the premarital portion of your savings, and the exact steps required to ensure that a 401k split doesn't trigger a massive, unnecessary bill from the IRS. To understand the 401k landscape in the Midwest, we first have to understand the philosophy of the region's legal systems. Most Midwest states operate under the principle of equitable distribution, unlike community property states, which often mandate a strict 50-50 split of all assets acquired during the marriage. Equitable distribution states focus on what is fair. However, fair is a subjective term that gives judges a massive amount of discretion. In a case study involving a long-term marriage in rural Nebraska, a judge might look at a stay-at-home parent's non-monetary contributions to the household as a reason to award a significant portion of the working spouse's 401k, even if that spouse was the sole contributor to the fund. Historical trends in states like Iowa and Indiana show that courts often start at a 50-50 baseline for assets earned during the marriage, but they can deviate based on the length of the marriage, the economic circumstances of each spouse, and even the future earning potential of both parties. One of the most critical distinctions we must make is between marital property and separate property. In the context of a 401k, this is where many people in the Midwest lose their footing. Let's say you started your 401k 5 years before you got married. At the time of your wedding, you had $50,000 in the account. Over the next 15 years of marriage, that account grew to $500,000. A common misconception is that the entire $500,000 is now marital property. In reality, that initial $50,000, along with the passive growth associated with that specific $50,000, might be considered separate property if you can properly trace it. However, if you cannot provide the historical statements or if you commingled those funds in a way that makes them indistinguishable from the marital contributions, a court in Ohio or Wisconsin might simply classify the entire balance as marital property. This underscores the necessity of deep-dive financial forensics during the discovery phase of a divorce. Another layer of complexity involves the valuation of the 401k itself. In the Midwest, the valuation date is a pivotal point of contention. Is the account valued on the date the divorce petition was filed? Is it valued on the date of the final hearing? Or perhaps on the date the couple separated? In a volatile market, the difference between a valuation in June and a valuation in December could be $60,000 or $70,000 on a large 401k. We see case studies where a spouse who is entitled to 50% of an account sees their actual dollar amount plummet because the market dipped between the agreement and the actual transfer of funds. Understanding how to lock in a specific dollar amount versus a percentage is a nuanced strategy that can drastically change potential outcomes. Furthermore, we have to address the Qualified Domestic Relations Order, or QDRO. This is perhaps the most misunderstood document in the entire American financial system. A divorce decree issued by a judge in a Midwest county court is a powerful document, but it has no direct authority over a 401k plan administrator. A 401k is governed by federal law, specifically ERISA, the Employee Retirement Income Security Act. Because of this, the plan administrator cannot simply cut a check to an ex-spouse because a local judge said so. They require a QDRO, a specific legal order that meets the strict requirements of both the internal 401k plan and federal law. Historical data suggests that thousands of divorcees in the Midwest fail to finalize their QDROs until years after their divorce, only to find that their ex-spouse has already retired, died, or emptied the account. This masterclass is going to walk you through the step-by-step reality of these challenges. We aren't just talking about numbers on a spreadsheet. We are talking about your ability to afford a home in a Midwest suburb, your ability to help your children with college, and your ability to retire with dignity. The Midwest has a unique economic profile, often characterized by stable, long-term employment in sectors like manufacturing, agriculture, and healthcare, which means 401ks are often the single largest asset a couple owns, sometimes even surpassing the equity in their home. The stakes are incredibly high. We will explore how different states handle active versus passive appreciation, and why a 401k loan taken out during the marriage might be considered a marital debt that offsets the total value of the account. This is the foundation of your financial future, and in the Midwest, the details aren't just important, they are everything. Moving forward, we will peel back the layers on how to navigate these waters without sinking your retirement ship. To understand how to protect your retirement, we must first look at the invisible lines drawn across the map of the United States. While some states like Wisconsin follow community property rules, the vast majority of the Midwest, including Illinois, Ohio, Michigan, and Indiana, operates under the system of equitable distribution. This is a critical distinction because it means the court is not looking for an equal split, but a fair one. To see how this plays out in the real world, let us look at a case study from early 2026 involving a couple we will call David and Emily, living in a suburb of Columbus, Ohio. David has spent the last 15 years building a career in logistics, and his 401k has grown to a substantial $450,000. Emily spent a portion of the marriage working part-time, while managing their household and raising their 2 children. In the eyes of an Ohio judge, that $450,000 account is a marital asset, but the way it gets divided depends on a granular analysis of their shared history. The first step in any deep dive into 401k division is the identification of marital versus separate property. Imagine if David had started his 401k 5 years before he ever met Emily. During those 5 years, he contributed $50,000. Historical trends in Midwest courts show that this initial $50,000, plus the passive growth that occurred on that specific $50,000 throughout the marriage, could potentially be classified as separate property. However, this is where many residents of the Midwest fall into a trap. In 2026, the burden of proof lies heavily on the person claiming the separate property. If David cannot produce the account statements from the day he and Emily were married, the court may default to viewing the entire balance as a marital asset. This is known as commingling. If you cannot trace the separate funds with mathematical certainty, the law often treats the entire pot as if it were created by the partnership of the marriage. Let us break down the mathematics of fairness used by many Midwest jurisdictions. A judge will look at the length of the marriage first. For a marriage of 20 years, the starting point is almost always a 50-50 split of the marital portion. But for a shorter marriage, perhaps 7 years, a judge in a state like Michigan might lean toward a different potential outcome. They might consider the economic circumstances of each spouse at the time the division is to become effective. If David earns $150,000 a year and Emily earns $40,000, the court might determine that Emily requires a larger share of the retirement assets to offset the fact that she has fewer years left to build her own nest egg. This is not about punishment. It is about ensuring that both parties leave the marriage with some level of financial stability. The year 2026 has introduced new layers of complexity due to market volatility. Let us look at the concept of the valuation date. In a Midwest divorce, the date the 401k is valued can change everything. Imagine if David and Emily filed for divorce in January 2026 when the market was at an all-time high. By the time they reach a final settlement in August 2026, the market has undergone a significant correction, and the 401k has dropped 15% in value. If their divorce decree states that Emily is to receive a specific dollar amount, say $225,000, and the account has shrunk, David is left with a much smaller percentage than he originally anticipated. Conversely, if the decree states Emily is to receive 50% of the account value as of the date of transfer, she shares in the market loss. Historical trends show that many people fail to specify whether they are agreeing to a percentage or a flat dollar amount, leading to intense litigation when the market moves during the pendency of the case. Step by step, the process moves from identification to valuation, and then to the most technical phase, the creation of the Qualified Domestic Relations Order, or QDRO. You must understand that your divorce decree is merely a roadmap. The QDRO is the vehicle that actually moves the money. In the Midwest, many plan administrators for major employers, think of the large healthcare systems in Minnesota or the manufacturing giants in Illinois, have incredibly specific requirements for these documents. If the QDRO is not drafted to match the specific language of the plan, it will be rejected. This can result in months of delays and thousands of dollars in additional legal fees. Consider the scenario of a 401k loan, which is common among Midwest families who may have used the funds for a down payment on a house or to consolidate debt. If David has a $30,000 outstanding loan against his 401k, how is that handled? In many Midwest courts, that loan is treated as a marital debt. If the total account value is $400,000 but there is a $30,000 loan, the court is actually looking at a net value of $370,000. However, the plan administrator will only transfer a portion of the actual balance. This means the parties must decide if the spouse receiving the funds will also take on a portion of the loan liability, or if the loan will be credited against the other spouse's share of different assets, like the equity in the family home. Another critical factor in the Midwest is the consideration of taxes. A 401k is pre-tax money. If David has $100,000 in a 401k and Emily has $100,000 in a standard savings account, these are not equal assets. When Emily eventually withdraws money from the 401k in retirement, she will owe income tax on every dollar. The savings account money has already been taxed. Case studies from 2026 indicate that savvy negotiators in states like Indiana and Missouri are now insisting on tax affecting these assets. This means they calculate the potential tax hit and adjust the distribution so that the person receiving the 401k gets a slightly larger nominal amount to account for the future tax liability they are inheriting. We must also talk about the timing of the transfer. Under Internal Revenue Code Section 72T, there is a very specific and often overlooked exception for 401k transfers incident to a divorce. Normally, if you take money out of a 401k before age 59 and a half, you pay a 10% penalty plus income taxes. However, if the transfer is done correctly via QDRO, the recipient spouse has a one-time opportunity to take a cash distribution from their share without paying that 10% penalty. They will still owe income tax, but the penalty is waived. This is a vital tool for a spouse in the Midwest who might need immediate liquidity to secure a new apartment or buy a car after the split. But if they roll the money into their own IRA first and then try to withdraw it, that 10% penalty comes roaring back. This is a mistake that costs Midwest families millions of dollars every year simply because they did not understand the sequence of the transfer. As we look at these potential outcomes, it becomes clear that the 401k is not just a bank account. It is a complex legal entity. In the next part of this deep dive, we are going to look at the specific traps that occur when one spouse has multiple accounts from different employers across state lines. What happens when a Michigan-based 401k meets an Illinois-based pension plan? The intersection of these different sets of rules can create a financial storm that most people are completely unprepared for. We will also uncover the hidden truth about what happens to your 401k if your ex-spouse remarries before the QDRO is finalized, a scenario that has led to some of the most heartbreaking historical trends in the legal world. Stay with us as we move into the mechanics of the multi-account trap and the race against the clock. The multi-account trap is a phenomenon that frequently catches Midwest professionals off guard, particularly those who have built careers across the interconnected economic corridors of the Great Lakes region. In 2026, it is common to find an individual who spent a decade at a manufacturing headquarters in Detroit before taking a senior role at a financial services firm in Chicago, and perhaps finishing their career at a tech startup in Minneapolis. Each of these stops likely left behind a separate retirement vessel, a legacy 401k here, a frozen pension plan there, and a current 403b or 401k with a different set of vestment rules. When a divorce is filed in a place like Cook County, Illinois, the court must grapple with a constellation of accounts governed by different plan administrators, each with their own internal set of rules and federal ERISA compliance standards. Imagine a professional named Marcus, living in the Milwaukee area in 2026. Over his 20-year career, Marcus has accumulated 3 distinct retirement accounts. One is a legacy 401k from a former employer in Indianapolis with $150,000. The second is a vested pension from a decade spent at a heavy equipment manufacturer in Peoria, Illinois. The third is his current 401k in Wisconsin, valued at $300,000. His spouse, Elena, is entitled to an equitable share under Wisconsin law. The trap here is the assumption that a single paragraph in the divorce decree can cover all 3. Historical trends show that treating these as a single lump sum is a recipe for administrative failure. Marcus and Elena might agree that Elena gets $250,000 from the total pool, but the Indianapolis 401k plan administrator will only recognize a qualified domestic relations order specifically tailored to their plan's language. If that plan doesn't allow for a lump sum payout to an alternate payee, the entire settlement agreement could be rendered unworkable. The technicality of the multi-account trap deepens when we look at the difference between defined contribution plans, like a 401k, and defined benefit plans such as a traditional pension. In the Midwest, where union-backed manufacturing and legacy corporate structures still hold significant weight, pensions are a common point of contention. Dividing a pension requires a different mathematical approach, often involving the marital foundation formula. In a case study from 2026, an Illinois court might apply the Hunt formula, which calculates the marital portion by dividing the months of service during the marriage by the total months of service at the time of retirement. This creates a future interest rather than an immediate cash value. If Marcus's Peoria pension is divided this way, Elena might not see a dime of that money for another 15 years. If the legal team hasn't accounted for this delay, Elena could find herself with a massive paper asset, but no actual cash to fund her post-divorce life in 2026. This leads us directly into the race against the clock. One of the most dangerous misconceptions in a Midwest divorce is that the 401k is safe once the judge signs the final judgment of dissolution. In reality, that judgment is nothing more than a permission slip to begin the real work. Between the signing of the divorce decree and the final approval of a QDRO by the plan administrator, there exists a period of extreme vulnerability. Historical trends indicate that this window can stay open for 6 months to a year, or even longer if the paperwork is rejected. During this time, the account owner still maintains full legal control over the account's beneficiary designations and investment choices. Consider a high-stakes scenario where the account owner, Marcus, unexpectedly passes away after the divorce is finalized, but before the QDRO is officially qualified by the plan administrator. Under federal ERISA law, the 401k plan must pay the death benefit to the beneficiary on file. If Marcus had removed Elena as the beneficiary following the divorce, but the QDRO wasn't yet in place to carve out her legal share, Elena could potentially lose her entire settlement. Federal courts have historically ruled that the plan's documents and beneficiary designations trump state-level divorce decrees. This is why seasoned legal professionals in 2026 insist on a preliminary injunction or a joinder of the plan during the divorce process to freeze the assets and protect the alternate payee's interest, while the QDRO is being drafted. The race against the clock becomes even more frantic if the account owner decides to remarry shortly after the divorce. This is a situation that has created some of the most complex legal battles in the U.S. Midwest. Under federal law, a new spouse automatically gains certain rights to a 401k plan. If Marcus marries a new partner, let's call her Sarah, In late 2026, before Elena's QDRO is finalized, a legal conflict arises between the ex-spouse's rights under the divorce decree and the new spouse's rights under federal law. Case studies have shown that without a properly executed and approved QDRO, the new spouse's claim to the survivor benefits can supersede the ex-spouse's claim. This is a nightmare scenario where the money you spent 20 years helping to build ends up in the hands of a person you have never met, simply because of a clerical delay in a county clerk's office. Furthermore, we must look at the administrative hurdles within the Midwest's specific employer base. Large entities like the University of Michigan, the Cleveland Clinic, or the various blue-chip firms in the Chicago Loop often use third-party administrators for their retirement plans. These administrators are not interested in the nuances of your divorce. They are interested in whether your QDRO contains the precise magic words required by their plan document. Step by step, the drafting process involves obtaining the plan's specific QDRO procedures, submitting a draft for pre-approval, obtaining the judge's signature on the final version, and then sending a certified copy back to the plan administrator for final qualification. If at any step the language is slightly off, perhaps it fails to address how earnings and losses are calculated between the valuation date and the transfer date, the administrator will reject it, and you must start the cycle over again. In 2026, the rise of digital assets within 401k self-directed windows has added a new layer of volatility. Some Midwest professionals now have a portion of their 401k allocated to institutional cryptocurrency trusts or private equity sleeves. These assets do not have daily liquidity and are notoriously difficult to value and divide. If Marcus's 401k includes a private equity component that won't be liquid for another 5 years, how does Elena get her share? Historical trends suggest that courts may require an offset, where Elena receives a larger share of the liquid assets, like the house or a different 401k, to compensate for the fact that she cannot access the illiquid portion. However, this requires an accurate appraisal of an asset that, by its nature, is hard to price. As we navigate this maze, it is crucial to recognize that the 401k is often the last line of defense for a person's financial future. Mistakes made during the multi-account division or the QDRO race are often permanent. There is no undo button once the money has been distributed or once a beneficiary right has vested in a new spouse. This part of the deep dive has shown you the structural risks, but we have yet to touch on the most immediate and painful trap: the hidden tax implications and the massive IRS bills that can arrive months after the divorce is over. In the next part, we are going to expose the tax bracket shift that happens when one spouse inherits a massive 401k balance, and the specific way the 20% mandatory withholding can destroy your liquidity if you aren't prepared for it. We will also reveal why your choice of a 401k versus a Roth 401k in the settlement could be $1 million decision that you only realize 20 years too late. The math of the IRS is coming next, and it is far more aggressive than the math of the divorce court. The Internal Revenue Service does not care about the emotional weight of your divorce or the years of sacrifice you put into your marriage. In the eyes of federal tax law, a 401k is a tax-deferred vehicle, and the moment that money moves, the IRS is standing at the door ready to collect. When you are navigating a 401k split in the Midwest in 2026, you are not just dividing an account, you are dividing a future tax liability. If you do not account for this, the person who thinks they are walking away with $500,000 might actually be walking away with $340,000 after the government takes its share. This is the math of the IRS, and it is far more aggressive than the math of the divorce court. Let us look at a case study involving a woman named Sarah from Indianapolis. In early 2026, Sarah and her husband finalized their divorce. As part of the equitable distribution, Sarah was awarded $200,000 from her husband's traditional 401k. Sarah, needing to secure a new home and pay off legal fees, decided to take that $200,000 as a cash distribution rather than rolling it over into her own IRA. Here is where the potential outcomes turn into a financial nightmare. Under federal law, when a 401k plan administrator cuts a check directly to an alternate payee following a QDRO, they are legally required to withhold 20% for federal income taxes immediately. Sarah expected a check for $200,000. Instead, she received $160,000. But the $40,000 sent to the IRS was only a down payment. Because Sarah lives in Indiana, she also owes state income tax, which is roughly 3.23%, plus potential local county taxes. Furthermore, that $200,000 is added to her other income for the year 2026. If Sarah earns $60,000 at her job, Her total taxable income for the year just jumped to $260,000. This catapults her from a 22% federal tax bracket into the 35% bracket. When she files her taxes in April 2027, she will find that the 20% withheld was nowhere near enough. She will owe the IRS another 15% on that distribution, plus state taxes. Sarah's $200,000 settlement quickly eroded into less than $130,000 of actual purchasing power. This historical trend of ignoring the tax bracket jump is one of the most common ways Midwest divorcees find themselves in unexpected debt. Imagine if, instead of taking cash, Sarah had been advised on the difference between a traditional 401k and a Roth 401k. In the U.S. Midwest, many corporate employees at companies like Salesforce in Indy or Ford in Michigan have been utilizing Roth 401k options. $1 in a Roth 401k is fundamentally more valuable than $1 in a traditional 401k because the taxes have already been paid. If a couple is dividing $100,000 in a traditional 401k and $100,000 in a Roth 401k, giving one spouse the traditional and the other the Roth is not an equal split. The spouse with the traditional account has an invisible debt to the IRS attached to every cent. In a 2026 deep dive into asset valuation, professionals often use a concept called tax affecting. This involves calculating the future tax hit on the 401k and reducing its present value accordingly. If the projected tax rate is 25%, that $100,000 traditional 401k is only worth $75,000 in real-world spending power. Now, let us look at the specific 10% penalty exception that we mentioned earlier, because in 2026, this is still one of the most powerful tools for liquidity if used correctly. Under Internal Revenue Code Section 72T2C, a distribution from a qualified plan like a 401k to an alternate payee under a QDRO is exempt from the 10% early withdrawal penalty, even if the recipient is under age 59 and a half. This is a one-time window of opportunity. However, step by step, the money must go directly from the 401k to the spouse. If the spouse first rolls the money into their own individual retirement account, IRA, and then takes a withdrawal, the 10% penalty applies. This is because IRAs are governed by different sections of the tax code that do not recognize the QDRO exception. We have seen case studies where a spouse in Milwaukee rolls $300,000 into an IRA on a Monday and withdraws $50,000 on a Tuesday, only to realize they just triggered a $5,000 penalty that could have been avoided with a direct distribution from the 401k. The state-level nuances in the Midwest add a third layer of complexity. Take Illinois, for example. Historically, Illinois has been one of the few states that does not tax most retirement income, including 401k distributions, provided the recipient meets certain age requirements or the plan is a qualified one. Compare this to Michigan or Iowa, where the tax treatment of retirement assets has undergone significant legislative shifts in the mid-2020s. If you are a resident of Chicago receiving a 401k share, your net outcome might be significantly higher than if you were receiving that same share across the border in Gary, Indiana. In 2026, failing to look at the state-specific tax forms can lead to a 3 to 5% variance in your total net worth post-divorce. There is also the matter of net unrealized appreciation, or NUA. This is a high-level tax strategy that applies to Midwest employees who hold significant amounts of their employer's stock within their 401k. Think of longtime employees at Boeing or Caterpillar. If a 401k contains highly appreciated company stock, taking a distribution of the stock itself, rather than selling it within the plan, can allow the recipient to pay lower capital gains tax rates on the growth, rather than higher ordinary income tax rates. In a divorce, if the QDRO allows for the transfer of the company's stock in kind, the ex-spouse might inherit this NUA treatment. This is a specialized area where a mistake in the QDRO language, such as ordering the plan to liquidate all assets to cash before transfer, can permanently destroy hundreds of thousands of dollars in tax savings. To manage these risks, a step-by-step tax strategy is required. First, identify the type of 401k, traditional versus Roth. Second, calculate the marginal tax bracket of the recipient spouse post-divorce. Third, determine the immediate liquidity needs to see if the 10% penalty exception should be utilized. Fourth, verify the state tax laws in your specific Midwest jurisdiction. And fifth, ensure the QDRO is drafted to facilitate the chosen path, whether it is a direct rollover to an IRA to defer taxes or a partial cash distribution to provide immediate funds. As we have seen, the IRS is a relentless participant in your divorce. But taxes are only half of the story. While the government is looking at your income, your 401k plan administrator is looking at the market. There is a hidden phenomenon known as the ghost in the machine. The way that administrative fees, investment management costs, and hidden transaction charges can quietly bleed a 401k during the months it takes to process a divorce. In the next part, we are going to dive into the world of valuation errors and hidden fees. We will look at how an outdated account statement can lead to a $50,000 mistake, and why the way your 401k is invested during the divorce could be a form of financial sabotage. We will also uncover the truth about who pays the thousands of dollars in QDRO processing fees that the plan administrators never mention until the very end. The battle for the actual value of the account starts now. The battle for the actual value of a 401k starts the moment the divorce petition is filed in a Midwest courthouse. But the numbers you see on your quarterly statement are often a financial mirage. We have to discuss the ghost in the machine, which is the administrative and market-driven friction that can siphon tens of thousands of dollars away from a settlement before a single cent is ever transferred. In the U.S. Midwest, where many residents hold long-term positions at massive employers like Ford, General Motors, or the Mayo Clinic, these accounts are not just static buckets of cash. They are living, breathing financial entities subject to internal plan rules that most people never read until they are in a lawyer's office in 2026. Let us look at a case study involving a character named James, a 52-year-old automotive engineer in Detroit, Michigan. In early 2026, James and his spouse are dividing a 401k valued at $800,000. They agree on a 50-50 split based on the date of filing. However, what James and his spouse do not realize is that the plan administrator, a third-party entity like Fidelity or Alight, charges a specific QDRO processing fee. In 2026, these fees typically range from $500 to $1,500 per account. While that may seem small relative to $800,000, the question of who pays that fee is a common point of litigation. Does it come out of the total balance before the split? Or is it deducted solely from the alternate payee's share? If the divorce decree is silent on this, the plan administrator often defaults to their own internal policy, which can lead to one spouse feeling blindsided by a sudden deduction they never agreed to. Beyond the administrative fees, we must address the earnings and losses clause. This is where more money is lost or gained by accident than almost anywhere else in the divorce process. Imagine if James's 401k grows by 12% between the day they decide on the split and the day the QDRO is finally approved 6 months later. If the legal document states that the ex-spouse is to receive a specific dollar amount, such as $400,000, then James keeps all of that 12% growth on the entire $800,000 while the paperwork is processed. This is a massive windfall for the account holder. Conversely, if the market crashes during those 6 months, James is still legally obligated to pay out that full $400,000, even if the total account value has dropped to $650,000. This would leave James with only $250,000. Historical trends show that failing to specify whether the award includes proportional gains and losses is the #1 cause of post-decree legal battles in states like Illinois and Ohio. Step by step, you must ensure your legal team addresses the valuation date versus the transfer date. In a 2026 Midwest market, volatility is the baseline. To protect your interest, the QDRO should clearly state that the alternate payee receives a percentage of the account as of a specific date, plus or minus any investment earnings or losses attributable to that share until the date of distribution. This ensures that both parties share the market risk and the market reward equally during the administrative waiting period. Now let us explore a more sinister potential outcome: investment sabotage. Because the account holder typically maintains control over the 401k investments during the divorce process, there is a risk of what courts call a breach of fiduciary duty to the marital estate. Imagine if James, feeling bitter about the 50-50 split, decides to reallocate the entire 401k into high-risk speculative assets or, conversely, moves everything into a low-yield money market fund during a major bull run. If the market climbs 20% and James has sat in cash, the marital estate has lost out on $160,000 of potential growth. In many Midwest jurisdictions like Wisconsin and Minnesota, courts have the power to issue status quo orders. These orders legally prohibit either spouse from making significant changes to investment allocations or taking loans against the 401k without written consent or a court order. If you are going through this in 2026, ensuring a status quo order is in place on day one is a critical step in protecting the account's integrity. We also need to perform a deep dive into the passive versus active appreciation of premarital funds. This is a technical battlefield in the Midwest. Suppose James had $100,000 in his 401k before he got married. 20 years later, that $100,000 has grown to $300,000 simply because the market went up. This is passive appreciation. However, if James was actively trading stocks within that 401k during the marriage, some Midwest courts might argue that the growth is a marital asset because his labor and expertise, which belong to the marriage, were used to create that wealth. Case studies in Michigan have shown that tracing these funds requires a forensic accountant. They will use the Majowska's formula or similar curvature fractions to determine what portion of that growth is truly separate. Imagine if the expert determines that 60% of the growth was active. James could lose hundreds of thousands of dollars he thought were safely premarital. Another hidden trap in the Midwest is the 401k loan offset. Many workers in the manufacturing or healthcare sectors take loans from their 401ks to fund home renovations or consolidate debt. In 2026, if James has an outstanding $40,000 loan, the plan administrator views the account value as the cash balance plus the loan. If the cash is $760,000 and the loan is $40,000, the total is $800,000. If the spouse is awarded 50%, they are expecting $400,000. But the plan administrator will only transfer 50% of the available cash, which is $380,000. The remaining $20,000 of the award must be handled by James paying the spouse directly, or by offsetting it with other marital assets like equity in the house or a car. If this isn't calculated correctly at the mediation table, the receiving spouse ends up with a $20,000 shortfall that can take months of litigation to recover. Furthermore, we must consider the vesting schedule. In the Midwest tech and startup scene, as well as in some corporate roles in Chicago, 401k matching contributions often vest over a 3 to 5 year period. If James is only 60% vested in his employer's contributions at the time of the divorce, the 401k statement might show a total balance that includes unvested funds. A common mistake is to divide the total balance, only to find out later that the unvested portion was forfeited when James changed jobs, or that the plan administrator refuses to transfer unvested money to an ex-spouse. The QDRO must specifically address how unvested shares are handled, whether they are ignored, divided if and when they vest, or if the vested portion is used as a baseline. This level of detail is what separates a standard divorce from a masterclass level financial separation. You are not just moving numbers. You are navigating the internal legal documents of billion-dollar corporations and the specific precedents of state-level appellate courts. But even if you get the valuation and the fees right, there is a massive regional factor in the Midwest that can completely flip the script on your 401k. In many Midwest states, there is a hidden interaction between your 401k and something you might not even realize is on the table: your Social Security offset. In the next part, we are going to dive into why being a teacher, a police officer, or a government worker in states like Ohio or Illinois can lead to a 401k division that feels wildly unfair. We will uncover the truth about how a private sector 401k is compared to a public sector pension, and why the law might take more of your 401k just because your spouse doesn't pay into Social Security. This is the windfall elimination provision and the government offset trap, and it is the most controversial part of Midwest divorce law. If you don't understand the hypothetical Social Security math, you are walking into a trap that can cost you your entire retirement. The interaction between public sector pensions and private sector 401k accounts is the invisible tectonic plate of Midwest divorce law. In states like Ohio, Illinois, Kentucky, and Missouri, a massive portion of the workforce is employed in the public sector as teachers, police officers, firefighters, and state employees. Many of these professionals do not participate in the Social Security system. Instead, they contribute to comprehensive state pension plans like STRS in Ohio or TRS in Illinois. When one spouse has a standard 401k and the other has a public pension, the mathematical fairness of the split enters a realm of complexity that most people in 2026 are completely unprepared for. This is where the concept of the hypothetical Social Security offset becomes a central, and often highly litigated, factor. Under federal law, Social Security benefits are not considered marital property and cannot be divided by a state court. However, a 401k is a private asset that is absolutely divisible. This creates a massive imbalance. Imagine a case study involving a couple in Cleveland, Ohio, in 2026. We will call them Robert and Linda. Robert has worked in the private sector for 30 years, and has accumulated a 401k valued at $600,000. Linda has been a public school teacher for the same 30 years and has a vested pension that will pay her $5,000 a month upon retirement. Because Linda did not pay into Social Security through her teaching job, she will not receive those federal benefits. Robert, however, has paid into Social Security and expects a monthly benefit of $2,500. In a standard equitable distribution, a court might look at Robert's $600,000 401k and say that Linda is entitled to half, or $300,000. But what about Linda's pension? The pension is also marital property. However, in Ohio and several other Midwest states, the courts have adopted a principle established in historical trends like the case of Neville versus Neville. The court recognizes that Robert's future Social Security benefit, while not divisible, has a real economic value. If the court ignores Robert's Social Security but divides Linda's pension, Linda is left at a severe disadvantage because Robert keeps his entire Social Security benefit plus half of her pension. To correct this, the court may calculate a hypothetical Social Security benefit for Linda, essentially asking what Linda would have received from Social Security if she had been in the private sector. The court then offsets the value of the 401k or the pension to account for this disparity. The step-by-step math of this offset is grueling. To determine the value of this hypothetical benefit, experts must be brought in to perform a present value calculation. They look at the spouse's earnings history and apply the Social Security Administration's formulas to estimate what the benefit would have been. Once they have that monthly number, they must calculate how much cash would be needed today to fund that lifetime stream of income, accounting for life expectancy and inflation rates in 2026. If the expert determines that Robert's Social Security benefit has a present value of $400,000 and Linda's hypothetical benefit would have been $350,000, the court uses these figures as shadow assets to rebalance the 401k division. In many potential outcomes, this results in the private sector spouse keeping a much larger portion of their 401k than they originally anticipated, or conversely, the public sector spouse receiving a smaller share of the 401k to make up for their robust, guaranteed pension. This brings us to the federal rules that complicate this even further: the Windfall Elimination Provision, or WEP, and the Government Pension Offset, or GPO. Even if Linda had worked a side job and earned enough credits to qualify for some Social Security, the WEP could significantly reduce her benefit because she also has a public pension. In a divorce, if the legal team does not account for the WEP or GPO, they might overvalue a spouse's future income, leading to an inequitable split of the 401k. For instance, if Robert thinks he will receive Linda's spousal Social Security benefits after they have been married for 10 years, he might be shocked to find that the GPO could reduce his spousal benefit to zero because of his own government pension. These are not just minor deductions. They are structural shifts in retirement security that are unique to the Midwest's heavy concentration of non-Social Security employment. Imagine if you are the spouse with the 401k and you are told that you have to give up a larger share because your Social Security has value, but you also have to give up half of your 401k. This creates a feeling of double-dipping that is a frequent point of contention in Midwest courtrooms. Historical trends show that judges have a high degree of discretion here. Some judges in rural Illinois might find the hypothetical Social Security math too speculative and refuse to use it, while a judge in a tech-heavy suburb of Chicago might insist on it to ensure a truly equitable outcome. This lack of uniformity across county lines means that your location in the Midwest can be just as important as your account balance. In 2026, we are also seeing a rise in Social Security valuation reports being used as leverage during mediation. A savvy negotiator will present a report showing that their client's Social Security is worth far less than the other spouse's pension credits, arguing that the 401k should remain untouched to bridge the gap. This is especially prevalent in marriages where there is a significant age gap. If the younger spouse is the one with the 401k, they have more years of Social Security value to be used against them in the math of the offset. The complexity doesn't stop at the state line. If you lived in Michigan while earning part of your pension but moved to Indiana before the divorce, which state's offset rules apply? This conflict of laws can lead to forum shopping, where one spouse tries to file in the state with the most favorable treatment of Social Security offsets. In 2026, as remote work has shuffled the population of the Midwest, this has become a logistical nightmare for the courts. As we dive deeper into the masterclass, you have to realize that the 401k is often the balancing asset. When the house is sold and the cars are titled, The 401k is the flexible pot of money used to make the math work. But when you introduce the hypothetical Social Security trap, that flexible pot of money can suddenly disappear. You might think you are negotiating over a $500,000 account, but once the pension offsets and Social Security values are applied, you might only be fighting over $100,000 of it. Understanding this math is the difference between a retirement spent in comfort and one spent in financial anxiety. But even if you survive the Social Security offset, there is a final looming threat that most people ignore until it is too late. It is the post-divorce cleanup. What happens when the judge signs the paper the 401k is split, but you forget to change one specific document? In the next part, we are going to look at the beneficiary time bomb. We will explore case studies of ex-spouses who won millions of dollars in 401k assets years after a divorce simply because a name wasn't updated on a website. We will also reveal the forgotten loan trap that can trigger an immediate tax bill for a spouse who thought they were finally free. The paperwork you don't sign is often more dangerous than the paperwork you do. That race against the clerical clock starts now. The clerical race you enter the moment your divorce is finalized is often more high stakes than the litigation itself. In the United States Midwest, there is a pervasive and dangerous myth that once a judge in a county like Sedgwick, Kansas, or Douglas, Nebraska signs that final decree, your legal connection to your ex-spouse is severed. In reality, when it comes to your 401k, the judge's signature is merely the starting gun for a bureaucratic marathon where a single misstep can lead to a total loss of assets. This brings us to the first massive hazard in our masterclass, the beneficiary time bomb. To understand this, we must look at the supremacy of federal law over state law. Imagine a case study from early 2026 involving a man named Michael who lives in Wichita. Michael finalized his divorce from his wife, Jennifer, in late 2024. The divorce decree was crystal clear. Michael kept his $450,000 401k, and Jennifer explicitly waived any and all rights to that account in exchange for the equity in their family home. Michael, feeling a sense of closure, moved on with his life and remarried a woman named Sarah in 2025. Tragically, in early 2026, Michael passes away in a car accident. Sarah, his new wife, goes to claim the 401k, assuming she is the natural beneficiary. However, Michael never logged into his HR portal to change the beneficiary designation form. Jennifer, the ex-wife, is still listed as the primary beneficiary. In most people's minds, the divorce decree should override the old form. But historical trends and a landmark Supreme Court case known as Egelhoff versus Egelhoff tell a much darker story. Because 401ks are governed by ERISA, a federal law, the plan administrator is legally required to follow the plan documents and the beneficiary form on file, regardless of what a state-level divorce decree says. In this 2026 scenario, the plan administrator cuts a check for $450,000 to Jennifer, the ex-spouse. Sarah sues, pointing to the divorce decree where Jennifer waived her rights. In many potential outcomes across the Midwest, the federal court will rule that the plan administrator acted correctly. Jennifer keeps the money, and Sarah is left with nothing. This is the plan document rule. It is a cold, hard reality of federal preemption. The 401k does not care about your intent. It only cares about the paperwork in the file. The step-by-step fix for this is not just updating the form. It is understanding the hierarchy of beneficiaries. You have primary beneficiaries and contingent beneficiaries. In 2026, with the rise of digital estate planning, many Midwest employees assume that a mention in a digital will or a legacy contact on a social media app is sufficient. It is not. You must ensure that the specific 401k plan administrator has an updated, signed, and acknowledged designation. Furthermore, some plans in the Midwest, particularly those for legacy manufacturing firms, require a spouse's written consent to name anyone else as a beneficiary. If Michael had tried to name his children as beneficiaries while still married to Sarah, but failed to get her notarized waiver, the designation might be invalid anyway. The clerical clock is relentless. This leads us directly into the second hazard, the forgotten loan trap. In the Midwest, it is common for workers in the agricultural or logistics sectors to take loans against their 401k to fund large purchases or consolidate high-interest debt. Let us continue with the case study of Michael and Jennifer, but imagine they are still in the process of dividing assets in 2026. Michael has a $30,000 outstanding loan on his 401k. The total balance is $200,000, but the cash value is only $170,000 because of that loan. During the divorce negotiations, they agreed to split the account 50-50. Here is where the potential outcomes become disastrous. If the QDRO is not drafted with surgical precision, the plan administrator might interpret 50% as 50% of the total account value, which includes the loan. This means Jennifer is awarded $100,000. But because there is only $170,000 in cash, the plan administrator must take $100,000 out of that cash to give to Jennifer, leaving Michael with only $70,000 in cash and a $30,000 debt. To make matters worse, if Michael loses his job or the company is sold, a frequent occurrence in the shifting Midwest economy of 2026, that loan often becomes due immediately. If Michael cannot repay that $30,000 within a very short window, typically 60 to 90 days, the IRS treats the unpaid balance as a deemed distribution. Now Michael is hit with a double blow. He owes income tax on that $30,000 as if it were salary earned in 2026. If he is under age 59 and a half, he also owes a 10% early withdrawal penalty. Because he is in a Midwest state like Missouri or Kansas, he also owes state income tax. That $30,000 loan just turned into a $12,000 tax bill that Michael has to pay out of his remaining $70,000. Jennifer, meanwhile, walked away with her full $100,000. This is why a deep dive analysis of any outstanding 401k loans is mandatory before any settlement is signed. You must determine if the loan is a marital debt or a separate debt, and you must specify in the QDRO exactly how that loan affects the distribution. In 2026, we are also seeing the emergence of the automatic rollover trap. Many Midwest employers have moved to automated systems that automatically roll over small 401k balances into IRAs when an employee leaves. If a QDRO is in process but the employee leaves the company before it is finalized, the 401k might vanish from the plan administrator's system and reappear as an IRA at a completely different financial institution. This breaks the QDRO. A QDRO only applies to qualified plans like 401ks. If the money is now in an IRA, the ex-spouse legal team has to start over with a different set of legal documents and potentially a different court order. The delay can take months, and during that time, the account owner could theoretically withdraw the funds, leading to a hunt for assets across state lines. To survive the clerical race, you must act as your own project manager. Step 1 is to request the Summary Plan Description or SPD from the HR department. This document is the rulebook for the 401k. It tells you exactly how they handle QDROs, what their fees are, and how they treat loans during a divorce. Step 2 is to verify your beneficiary designations immediately, not after the divorce but during the process. While you are often prohibited from changing beneficiaries during a pending divorce due to standing orders, you need to know exactly who is on that form so you can prepare the update the minute the decree is signed. Step 3 is to coordinate with a tax professional to model the impact of any 401k loans or immediate distributions. The paperwork war is won in the details. But as we move forward in this deep dive, we have to address a topic that is even more shrouded in mystery than QDROs: the hidden world of forensic accounting. In the Midwest, wealth isn't always sitting in a simple 401k. It is often tucked away in executive deferred compensation plans, restricted stock units, and phantom stock. In the next part, we are going to look at the hidden assets of the Midwest professional. We will explore how a spouse might be hiding a second retirement account in a different state and the specific digital breadcrumbs that 2026 technology allows us to track. We will also reveal the lifestyle analysis technique that investigators use to prove that a 401k balance doesn't match the reported income. The search for the missing millions begins in Part 8. The loop is wide open and the numbers are about to get much bigger. The search for the missing millions in a Midwest divorce often begins not in a courtroom, but in the fine print of a W-2 form or the obscure submenus of a corporate HR portal. As we move into 2026, the landscape of retirement wealth for high-earning professionals in hubs like Minneapolis, Chicago, and St. Louis has shifted far beyond the standard 401k. For many executives and senior managers at companies like United Health Group, Target, or Boeing, the 401k is merely the tip of the iceberg. Beneath the surface lies a complex web of non-qualified deferred compensation plans, restricted stock units, and phantom stock that can dwarf the value of a traditional retirement account. If you are only looking at the 401k, you might be leaving 80% of the marital wealth on the table. Imagine a case study involving an executive we will call Mark, who has spent the last 20 years climbing the ladder at a major financial services firm in Des Moines, Iowa. In 2026, Mark's 401k statement shows a healthy balance of $600,000. His spouse, Sarah, assumes this is the primary retirement asset to be divided. However, a deep-dive forensic analysis of Mark's payroll records reveals a different story. In Box 12 of Mark's W-2 there is a code Y. To the untrained eye, this is just a letter. To a forensic accountant, code Y indicates deferrals under a Section 409A non-qualified deferred compensation plan. These plans allow high earners to defer a much larger portion of their salary and bonuses than the federal limits of a 401k allow. Mark has been quietly funneling $50,000 a year into this plan for a decade. The actual value of this shadow account is $750,000, and because it is not a 401k, it is not listed on his standard retirement statements. The potential outcomes for Sarah change drastically once this asset is identified. However, dividing a non-qualified plan is not the same as dividing a 401k. These plans are not governed by ERISA, which means a standard QDRO often will not work. Historical trends show that many corporate plans in the Midwest are top hat plans that are unfunded, meaning they are essentially a contract between the employer and the employee. If Mark's company goes bankrupt, that $750,000 could vanish. Because of this risk, Sarah's legal team in 2026 must decide whether to take a percentage of the future payments, which carries the risk of the company's insolvency, or to demand an offset from more secure assets like the equity in their West Des Moines home or the 401k itself. This leads us to the technical battlefield of restricted stock units or RSUs. In the Midwest tech and corporate sectors, RSUs have become a primary form of compensation. Imagine if Mark was granted 5,000 shares of company stock in 2024, but they vest over a 4-year period. By the time the divorce is filed in 2026, only 2,500 shares have vested. The other 2,500 are unvested. In many Midwest jurisdictions, including Illinois and Minnesota, the court must determine what portion of those unvested shares is marital. This is often calculated using a time rule formula or coverture fraction. The logic is that the shares were granted for work performed during the marriage, but they also serve as an incentive for Mark to stay with the company in the future. The step-by-step process involves subpoenaing the grant agreement to see if the vesting is based on time served or performance milestones. If Sarah's attorney fails to secure the grant letter, she might miss out on a stock windfall that occurs months after the divorce is finalized. In 2026, forensic accountants are also using lifestyle analysis to uncover hidden retirement shifts. This is a technique where investigators look at the reported income versus the actual expenditures of the household. Imagine if Mark's reported take-home pay in 2025 was $200,000, but the family's mortgage, travel, and luxury car payments in the Chicago suburbs totaled $250,000. Where did the extra $50,000 come from? A lifestyle analysis might reveal that Mark has been taking hidden distributions from an old 401k from a previous employer in Ohio that he never disclosed. In the digital age of 2026, these breadcrumbs are often found in PDF bank statements where a small, recurring deposit is labeled as a transfer from a financial institution Sarah doesn't recognize. We must also talk about the orphaned 401k. Historical trends indicate that the average American worker changes jobs 12 times in their career. In the interconnected economy of the Midwest, it is common for a professional to have a $40,000 account sitting with a former employer in Indianapolis and a $60,000 account in a pension fund in Wisconsin. In 2026, many individuals forget to disclose these smaller accounts, hoping they will go unnoticed. Forensic investigators now use specialized software to scan Social Security earnings records and past tax returns for evidence of contributions to these forgotten plans. Finding just one of these orphaned accounts can cover the entire cost of the forensic investigation and then some. The search for assets also extends into the realm of asset transformation. This is a strategy where an account holder attempts to move marital 401k funds into non-marital vehicles before the divorce is filed. In 2026, we are seeing case studies where individuals use their 401k's self-directed brokerage window to purchase illiquid assets or obscure private equity stakes that are difficult for a spouse to value. Imagine if Mark uses $100,000 of his 401k to buy a stake in a private real estate trust, managed by a business associate. On paper, the 401k value remains the same, but the asset is now locked away, and its true market value is obscured. To combat this, Sarah's team must demand a valuation of the underlying assets, a process that can involve expert testimony from commercial real estate appraisers. Step by step, the discovery process in a high-asset Midwest divorce must include: first, a request for all W-2s and 1099s from the last 5 years. Second, a full download of the benefits summary from the employer's internal portal. Third, a subpoena for the plan document and adoption agreement for any non-qualified plans. And fourth, a forensic review of all Box 12 codes and Schedule B interest and dividend payments. This is not just paperwork. It is the map to the treasure. But even when you find the money, you have to face the most difficult psychological and legal hurdle: the equitable versus equal debate. Just because you found an extra $1 million in a deferred compensation plan doesn't mean the judge will split it 50-50. In the Midwest, the contribution of the homemaker is a powerful but subjective factor. In the next part, we are going to dive into the courtroom strategies used to argue for more than 50% of the retirement pool. We will explore how economic misconduct and dissipation of assets can result in one spouse being awarded a massive penalty share of the 401k. We will also reveal the double-dipping defense, where high earners try to prevent their 401k from being used for both property division and alimony. The battle of the experts is moving from the spreadsheets to the witness stand. The loop is closing, and the stakes for your future lifestyle have never been higher. The transition from the discovery phase to the actual courtroom battle marks the moment where abstract numbers on a spreadsheet transform into a fight for survival. In the United States Midwest, the legal system is built on the foundation of equitable distribution, but as we navigate the complexities of 2026, the definition of what is fair has become a high-stakes debate between competing experts. We are now entering the phase where the witness stand becomes the center of the financial universe. This is where the contribution of the homemaker is weighed against the breadwinner's career trajectory, and where the concept of economic misconduct can lead to potential outcomes that strip an account holder of a much larger portion of their 401k than they ever anticipated. To understand how a 50-50 split can quickly become a 60-40 or even a 70-30 division, we must look at a case study involving a couple in a suburb of Milwaukee, Wisconsin. Imagine a character named Thomas, who worked as a senior vice president for a regional insurance giant, and his spouse, Patricia, who spent 24 years managing their household and raising their 3 children. By 2026, Thomas has accumulated a 401k valued at $1.2 million. Under a strict interpretation of marital property, one might assume Patricia is entitled to $600,000. However, Patricia's legal team introduces a vocational expert and a forensic accountant to argue for a disproportionate share. They argue that because Patricia stepped out of the workforce in the early 2000s, her earning capacity in the 2026 job market is virtually non-existent. She has no 401k of her own, and her future Social Security benefits, based on her limited work history, will be minimal. In historical trends across states like Wisconsin and Minnesota, judges have looked at this disparity in future earning power as a reason to award the non-working spouse a larger portion of the retirement assets to ensure they do not become a ward of the state in their later years. The argument for the contribution of the homemaker is a pillar of Midwest divorce law. It posits that the spouse who stayed home provided the domestic stability that allowed the working spouse to focus entirely on their career and the accumulation of that 401k. In a 2026 courtroom, this is not just a sentimental argument, it is a mathematical one. Patricia's team will present a lifestyle analysis showing that the family standard of living was built on the assumption of a shared retirement. If Thomas keeps 50% of the 401k while maintaining his $300,000 annual salary, and Patricia receives 50% of the 401k with no prospects for high-level employment, their post-divorce economic realities will be wildly unequal. Midwest judges often use the 401k as the primary tool to rebalance the scales of justice. However, the battle becomes even more intense when the issue of economic misconduct, or the dissipation of assets, is brought to the table. This is one of the most aggressive maneuvers in a Midwest divorce. Imagine if Thomas, anticipating the divorce in late 2025, began withdrawing funds from his 401k or taking excessive loans to fund a lifestyle that did not benefit the marriage. Perhaps he spent $50,000 on luxury travel with a new partner, or lost $100,000 in a speculative high-risk investment without Patricia's knowledge. In 2026, Midwest courts in states like Illinois and Ohio are increasingly strict about the fiduciary duty spouses owe to each other during the marriage. If Patricia can prove that Thomas wasted marital assets, the court can engage in a look-back period. They won't just split the remaining $1.2 million. They will add the $150,000 of wasted money back into the marital pot for the purposes of calculation. Thomas might find himself in a potential outcome where he is credited with having already received that $150,000, meaning Patricia receives a much larger slice of the actual cash remaining in the account. Step by step, the dissipation argument requires a precise paper trail. You must first identify the date of the de facto end of the marriage, the moment the relationship was irretrievably broken. Any significant, non-routine expenditure after that date is subject to scrutiny. If you are the spouse who suspects dissipation, your forensic accountant will scan the 401k transaction history for any withdrawal or loan that doesn't have a corresponding marital purpose, such as paying for the mortgage or the children's tuition. In the high-retention world of 2026 litigation, these digital breadcrumbs are often the smoking gun that changes the entire percentage of the split. Then we must address the sophisticated defense known as the double-dipping prohibition. This is a concept that high-earning professionals in the Midwest use to protect their retirement accounts from being used as both a property asset and an income source. Let's look at a case study from the Chicago area. Imagine Thomas is ordered to pay Patricia $5,000 a month in maintenance, or alimony. The court also divides his $1.2 million 401k equally. Thomas's legal team might argue that if the court uses the projected income generated by his half of the 401k to calculate his ability to pay alimony, they are essentially counting the same asset twice. Historical trends in Illinois, particularly following the principles laid out in major appellate cases, suggest that courts should avoid this double counting. If an asset is divided as property, the future income from that specific portion of the asset should not be factored into the maintenance calculation. This is a critical nuance that can save a professional hundreds of thousands of dollars over the course of a lifetime, but it requires a specialized expert to testify on the specific characterization of the funds. The battle of experts often comes down to the clash between the forensic accountant and the vocational expert. While the accountant is focused on the historical growth and the tax-affected value of the 401k, the vocational expert is focused on the human element. They will conduct an evaluation of the non-working spouse, looking at their education, past skills, and the 2026 labor market in their specific Midwest city. If the vocational expert can prove that Patricia is capable of earning a significant salary, Thomas can argue that her need for a disproportionate share of the 401k is reduced. This is a chess match where every move is backed by data, and the potential outcomes are decided by who can present the most compelling narrative of future financial need. As we move toward the conclusion of this masterclass, it is clear that the 401k is the ultimate prize and the ultimate weapon in a Midwest divorce. We have covered the identification, the valuation, the taxes, the QDRO traps, and the courtroom strategies. But there is one final silent factor that can undermine everything you have fought for. It is the long-term impact of inflation and the hidden costs of managing a divided account in the years after the decree is signed. Many people win the battle in court only to lose the war in the decade that follows because they didn't account for the post-divorce maintenance of their retirement. In the final part of this series, we are going to look at the post-game strategy. We will reveal the exact steps you must take in the first 48 hours after your QDRO is approved to ensure your money starts working for you immediately. We will look at a case study of a Midwest divorcee who turned a $300,000 settlement into a multi-million-dollar retirement through 2026 specific investment vehicles. And finally, we will expose the one document you must sign to ensure your ex-spouse can never come back for a second bite of the apple if your 401k grows significantly after the divorce. The final piece of the puzzle is the most important one for your long-term peace of mind. The masterclass concludes with the blueprint for your new financial life. The blueprint for your new financial life begins the exact second the plan administrator issues the notice of qualification for your qualified domestic relations order. In the U.S. Midwest, we see a recurring historical trend where individuals celebrate the legal victory of a signed decree, but fail to execute the administrative finish line. This final part of our masterclass is dedicated to the post-divorce execution strategy, ensuring that the assets you fought for actually move into your control and begin working for your future in the year 2026 and beyond. Imagine if you are Samantha, a healthcare administrator living in Omaha, Nebraska. It is June 2026, and after 18 months of litigation, your QDRO has finally been approved by your ex-husband's employer-sponsored 401k plan. You have been awarded $500,000. The mistake many people make is assuming the plan administrator will simply send a check. In reality, you are now entering a 48-hour window where every decision has massive tax and investment implications. Samantha's first step is to establish her own receiving account, In 2026, the most common potential outcome is a direct rollover into a traditional individual retirement account or IRA. By choosing a direct rollover, Samantha ensures the money moves from the 401k custodian to her IRA custodian without ever touching her personal bank account. This avoids the mandatory 20% federal tax withholding we discussed earlier and keeps the full $500,000 working for her retirement. Step by step, Samantha must contact her chosen financial institution to open a rollover IRA and obtain the specific wire or transfer instructions required by the 401k plan administrator. She must then submit the plan's distribution election forms. If Samantha needs immediate liquidity, perhaps to secure a new home in the Omaha suburbs, she might choose to take a partial distribution. As we noted in our deep dive on tax exceptions, she can take a cash payment directly from the 401k as an alternate payee without the 10% early withdrawal penalty, though she will still owe ordinary income tax. In 2026, a case study of a similar distribution showed that taking $50,000 for a down payment resulted in a net check of $40,000 after the mandatory withholding, with the remaining $450,000 rolling over tax-free into her IRA. One of the most overlooked technical details in 2026 is the in-kind transfer versus the cash liquidation. When the plan administrator moves the funds, do they sell the mutual funds and stocks within the 401k and send cash, or do they move the actual shares of the investments? If the market is volatile, being out of the market for the 7 to 10 days it takes for a check to mail and clear can be a massive risk. If the 401k was invested in a broad market index fund, and the market climbs 5% during that 10-day window, Samantha would effectively lose $25,000 in potential growth because her money was sitting in a non-interest-bearing clearing account. Historical trends suggest that whenever possible, requesting an in-kind transfer of identical assets can mitigate this market timing risk. Now, we must address the second bite of the apple: protection. Even after the QDRO is qualified, there is often a lag before the funds actually move. During this time, the account value can change. In many Midwest jurisdictions, a critical legal document known as a termination of interest or a mutual release of marital claims must be filed. This document ensures that once the $500,000 is moved, neither party can come back and claim a share of future growth or dividends that occurred after the valuation date. Imagine if the tech sector in the Midwest experiences a massive surge in late 2026, and that $500,000 grows to $600,000 before the transfer is complete. Without a clear legal boundary in the settlement language, the ex-spouse might attempt to litigate for a portion of that $100,000 gain. Protecting yourself means ensuring the QDRO specifies that the alternate payee is or is not entitled to interest and investment earnings from the valuation date to the date of distribution. In 2026, the long-term maintenance of these assets requires a deep understanding of the Midwest economic reality. While the cost of living in states like Iowa, Kansas, and Missouri remains lower than the national average, inflation continues to be a silent predator of retirement savings. For Samantha in Omaha, a $500,000 settlement feels like a massive sum today. However, if we look at historical trends of 3% average inflation, that $500,000 will have the purchasing power of only about $275,000 in 20 years. This means the investment strategy inside the new IRA cannot be overly conservative. Samantha must work with a professional to build a diversified portfolio that accounts for the Midwest premium. The reality that while her housing costs might be stable, healthcare and energy costs in the region are subject to significant fluctuations. Furthermore, we must discuss the management of fees. Inside a corporate 401k, fees are often subsidized or negotiated at a bulk rate. Once that money moves to a personal IRA, Samantha is responsible for the expense ratios of her mutual funds and the advisory fees of her wealth manager. A 1% difference in annual fees might seem negligible, but on a $500,000 balance over 20 years, that 1% can represent over $200,000 in lost wealth due to the erosion of compound interest. In 2026, savvy investors in the Midwest are increasingly moving toward low-cost exchange-traded funds and automated rebalancing to keep more of their settlement in their own pockets. The final clerical step in the blueprint is the beneficiary audit. We have mentioned this throughout the series, but its importance cannot be overstated as you finalize your new financial life. The moment the funds land in your new IRA, you must name new beneficiaries. This is your opportunity to ensure that your children, a trust, or a new partner is protected. In 2026, Many Midwest residents are utilizing transferable on death or TOD designations for their non-retirement accounts as well, creating a cohesive estate plan that bypasses the lengthy and expensive probate processes in states like Michigan or Ohio. As you stand at the finish line of your 401k divorce journey, remember that the numbers on the paper are only half the battle. The other half is the discipline to follow through on the administrative tasks that follow. You have navigated the equitable distribution laws, the QDRO drafting, the tax traps of the IRS, and the complexities of public sector offsets. You have moved from a position of marital uncertainty to one of individual financial agency. Samantha in Omaha now has a $450,000 IRA, a new home, and a clear understanding of her tax liabilities. She is no longer a passenger in someone else's retirement plan. She is the pilot of her own. This masterclass has provided the framework, the data, and the case studies to help you understand the potential outcomes of a Midwest 401k division. But as one chapter closes, another begins. While the 401k is often the largest liquid asset, it is rarely the only one. In the Midwest, the family home and the surrounding real estate often hold the emotional and financial keys to a successful transition. How do you handle a mortgage in a high-interest 2026 market? What happens when the 401k split isn't enough to buy out the other spouse's equity in the farmhouse or the suburban estate? We are opening a brand new loop to explore the hidden world of Midwest real estate divorce, where the laws of partition and the reality of property taxes can create an entirely new set of challenges. Stay with us as we pivot from the world of paper assets to the world of brick and mortar. The deep dive into the Midwest home is coming next.